Hey, a very good morning to you all, and good morning. Welcome to the session on this unique talk with Mr. Prabhu, housing guru, and the expert on all these topics. And Mr. Prabhu is a CA by profession, and he has authored quite a few books, one self-redevelopment, deemed conveyance, and other various topics related to housing societies and all other aspects of housing societies. And today the topic, and this is Kaivan Irani, your master of ceremonies and your host for today. Today our unique host, Mr. Sunil Sharma, because he isn't here, he's attending to family obligations, and kindly include him and his family in your prayers. Thank you very much and welcome again. And today the topic is on transfer of flats in a cooperative housing society. And Mr. Prabhu, if you can elaborate, what is the importance and the impact of the process of the transfer of flats?
Yeah. See, in a multi-story building, in order to manage the day-to-day affairs, we do a form of organization which is known as cooperative housing society, or sometimes we call it also under the apartment act condominium, or we also form a company. What happens is, in a multi-story building in a metro or in a tier 1, tier 2, or even in tier 3 cities, so a person cannot buy the land, he cannot even after buying the land construct the building.
Correct.
So what happens, in order to save the resources or to have an optimum use of the resources of land,
right?
So one of the person who is a builder or a landowner, he gets the land and then he enters into development agreement with the contractor or the developer. Thereafter they construct the building. Now once the flats are constructed, they sell the flats, and when you sell this flat, this particular flat is always sold either under the Maharashtra Ownership Flat Act, which is in the Maharashtra, or in other states also, respective states Apartment Act or Ownership Act. Now in Maharashtra, we have Maharashtra Ownership Flat Act. In the year 2016, we have got the Real Estate Regulation and Development Act 2016, which is effective from 1st May 2017. So the flats in a multi-story buildings are sold on an ownership basis to different individuals through a builder, and after more than 51% flats are sold, then they form an organization which is called a cooperative housing society or a condominium or a company, and thereafter the common amenities like garden, road, parking, all these and the land, compound, staircase, lift, and various water supply, drainage system, all these are transferred to the society. Correct. And thereafter or a legal body, and then the legal body takes care of all these services. So this system is called in Maharashtra cooperative housing society. Now what happens? Once you purchase the flat you are buying on ownership basis.
Correct.
But you become a member of the society to avail these common services.
The benefits of the common areas.
Absolutely. So therefore, there are dual concepts. What are the dual concepts? The dual concept is, one, you are an owner of the flat.
Correct.
Because you are an owner of flat, naturally you have undivided share in the land also.
Correct.
Because that could be 1%, 2% of the total units, total land.
Correct.
You are an undivided share.
Absolutely.
But because you are a member of the society, you will not be having a land and building in your name.
Correct.
That comes in the name of the society.
Right.
And by virtue of becoming a member, you enjoy all the benefits. And of course, as a member of the society, you are entitled to sell it, resell it. Correct. To a third party. Correct. On your death, you can also, give a nomination, and based on the nomination, it can be transferred to the nominee.
Transferred to the nominee.
Or by way of inheritance, or by way of a law of inheritance, or Indian Succession Act, Hindu Succession Act, whatever the various personal laws, Mohammedan law, right. All this, the property also can be inherited by the legal heirs.
Correct.
For which various documents are to be done.
Correct.
Today our concept, or today our discussion is transfer of flat in a cooperative housing society.
Correct.
So, how these transfers are happening? This transfer can happen by way of a sale.
Correct.
The question arises, if it is by sale, what are the documents need to be done?
Correct.
It can be by way of a gift. Correct. If it is a gift, whom the gift can be given, what will be the documents related to the gift, correct. And what will be the consideration, what procedure will be done by the society. Third, it can be by way of a release deed.
Right.
It can be, by way of exchange. the flats also can be exchanged.
Right.
It can be on account of the death of a member, that means by transmission of the, by way of inheritance.
Correct.
And then way of transmission. If the properties are getting transferred to another person,
right,
by way of various methodology or the mode that I have said, either by way of partition, exchange, or resale, or transfer deed, or release deed, whatever the methodology, or by way of inheritance,
correct,
then naturally the membership in a cooperative society also should be transferred.
Correct.
So therefore, the law related to cooperative housing society also need to be followed.
Right.
So that means, that is what I said, there will be two types of transfers, or twice transfers are happening. One of the flat transfer happening
Correct.
under the Transfer of Property Act, or under the law of inheritance that I am talking about.
Right.
The other transfer which is happening is the share capital in the society.
Correct.
By way of transfer of the shares. So therefore, in the case of a resale of the flat or the transfer of flat, this is what need to be looked into.
So basically there is two dual processes that need to be done simultaneously.
Absolutely.
Once the transfer, meaning the title,
Correct.
and then the membership of the society.
Absolutely correct. You have rightly pointed out.
Great, thank you, Mr. Prabhu. And so we'll begin. We have quite a few questions and interesting questions today by the members and the participants. Thank you all of you all for the participation. The first the first question is asked by Mr. Nandakumar Joshi from Thane. Now the question is that he's an old member in the redevelopment project. It's related to a redevelopment project, and the builder has not executed the agreement with him, meaning Mr. Joshi, due to some issues with respect to terms and conditions of the development, agreement. Now the building is complete, right, and the society has allotted the flat to this Mr. Joshi now in the new building. Now the thing is about the execution of the agreement, about the new flat matter, it's pending with MahaSewa, who asked the builder or the developer to give possession and execute the agreement. Now order pending for execution, as builder is not ready to execute the agreement, right? And he has taken possession. I mean, the builder he has taken possession as builder, agreed, and society allocated the flat to Mr. Joshi. Correct. Now he says that Mr. Joshi asks, can he sell the new flat and have share certificate and flat allotment letter from the society? Please advise according in this matter.
See, whenever the redevelopment happens,
correct,
the first and foremost document that is executed by the developer and the society is called development agreement. Correct. And in the development agreement, what happens is the society enters into various terms and conditions with the developer, saying that okay, after the redevelopment, every member based on their existing area will get so much additional area. Correct. And accordingly that will be free of cost, and then that will be captured in the development agreement, of course, and the rent and other things. Correct. Now, after the building is completed, or after the IOD is issued, or the commencement certificate is issued, it's the duty of the builder and the society both together to enter into an individual agreement with every flat purchase. With every, okay. Because every member of the society, what he does is he surrenders the old flat by virtue of a resolution in the general body, by virtue of a development agreement, to the builder, right, for the purpose of demolition and reconstructing the building or redeveloping the building. Once the redevelopment is done, naturally in the new building, the purchaser, that particular member is going to get a new flat. Correct. As against 500 square foot, now he'll get a 600 square foot. As against flat number 1, he may get flat number 203. Correct. So whatever is the new flat number. Now in this case, they are required to enter into an agreement which is known as Permanent Alternative Accommodation Agreement. This is called PEEE, Permanent Alternative Accommodation Agreement. Why we call it as a Permanent Alternative Accommodation Agreement? Because during the redevelopment, they are given the rent to have a temporary transit accommodation. Correct. So after the temporary transit accommodation period is over, that is construction period is over, in exchange of old flat, they are going to get a Permanent Alternative Accommodation Agreement, because they are exchanging the old agreement, correct, that is a old flat, of 500 square foot, now they are getting a 600 square foot.
Correct.
So this agreement is to be executed by the builder, making the society as a conferring party and the individual as a purchaser.
Correct.
Now, the question asked by Mr. Joshi from Thane is that he has got the flat. However, unfortunately, the developer has not entered into with him PAAA, Permanent Alternate Accommodation Agreement. He has not executed.
Correct. Okay.
Now, how he will get the title of the flat? Because in order to get the title of the flat, he need to have this agreement. Now, he does not have the title. In that case, he has gone to the RERA to get the agreement registered. Of course, RERA has passed the order according to him, but only in spite of that, the builder has not executed the agreement.
Correct.
Now he has to go to the RERA once again, get the order implemented. RERA has a mechanism wherein they will appoint a special officer and get the agreement registered. That process will go on.
Correct. Okay.
But that may take its own time. In the meantime, the question is whether Mr. Joshi can take the allotment letter from the society. The answer is absolutely right. He can take the allotment letter from the society. That allotment letter also can lead as an evidence of the title.
Correct.
The society may say, based on the development agreement so and so, you are allotted so and so flat of so and so area, and accordingly the position has already been given to you by the builder, building is completed, OC is received, and therefore this flat is being allotted to you. And this allotment letter can become a title document for Mr. Joshi till he gets a permanent alternate accommodation agreement. Second, even the society can also enter into permanent alternate accommodation agreement. Because at the end of the day, it is the society who had entered into development agreement.
Correct.
Society has received the flat that has already been handed over to Joshi. So instead of initially they can give allotment letter, thereafter society can also enter into a permanent alternate accommodation saying that so and so builder developed the building. Now that he is not cooperating, the society is entering into agreement with the member
Mr. Joshi.
in exchange of 500 square foot. Now he is getting 600 square foot. These are all captured in the development agreement. So this way the society also can make allotment agreement, permanent alternate accommodation agreement with Mr. Joshi. This is also possible. Third, of course, the share certificate is already there with them.
Right.
So therefore he is a member.
Correct.
Nobody can dispute. So allotment letter or a permanent alternate accommodation agreement given by the society is also sufficient to get the title.
Great. And is it possible on these basis of these documents, can he sell the flat to somebody?
Absolutely, absolutely.
Great.
There is no
Okay.
problem because, as I said, if there is a permanent alternate accommodation agreement, that is excellent, given by the builder.
Correct.
If it is not there, let it the society give allotment letter. Based on that, that gives him a title. He has a membership. Based on this, he can also do the resale of the flat.
Fantastic.
Absolutely, there won't be problem.
Thank you, Mr. Prabhu. Thank you for providing clarity. Really, really appreciate that. And also, Mr. Joshi has asked quite a few questions actually, so let's go to the next question. Now, the question number 2, if transfer of flat is not, well, you answered the question. The question is, if transfer of flat is not possible on the basis of the share certificate and allotment letter, what is the remedy? You've provided the remedy in the answer.
Based on that, it is possible.
Correct.
And if they want to go to the RERA and get the order executed, that also
That's
can be
correct.
done. Even the society also can enter into permanent order condition. There is no problem.
Perfect, perfect. So thank you, Mr. Prabhu. I expect that Mr. Nandakumar Joshi, Mr. Prabhu has provided clarity to all your queries. Now we move to the next question and the next individual, which is Mr. Hemant Mirji. And Mr. Hemant Mirji has also mentioned the society. It's known as New Nilesh Cooperative Housing Society. The demographic location is Dahisar West. Now, here the question is, what needs to be done by both the present persons and the present managing committee for an earlier transfer, meaning previously a transfer hasn't been done. So what can the managing committee and the present person can do in the sense that there is no paperwork involved, like there is no previous paperwork. And what can they do at this when they have to transfer the agreement, except that the share certificate has the person's name mentioned on it, and today this very person needs to sell the flat and request for an NOC requested by the purchaser of the unit. So when the present committee is checking the past records, they found no such transaction has been noted in the annuals of the society. So what is the what can the present committee do to take the process ahead, meaning progress?
Yeah, as I was saying in the beginning, what happens is there are two different laws in which the transfer of a flat takes place. One is the Transfer of Property Act.
Correct.
The other one is the Cooperative Societies Law. Under the Cooperative Society Law, it is the shares which are getting transferred. Now, the shares can only be transferred as per the amendment carried out in the Cooperative Societies Act only when there is a registered agreement or a document which is showing that the flats are getting transferred.
Correct.
So, if you do not have the right title interest of the flat or the shop in a housing society, then you cannot become a member of the society. Now, in a given circumstances, what our friend is trying to say, that the society does not have any document. Fine,
Correct.
yes, but naturally it may not be there. But the person who is occupying the flat today, who wants to sell the flat, his name is appearing in the share certificate.
Right.
Now, if you do not have the record, that does not mean that you cannot demand the records from the person whose name is incorporated in the share certificate.
Correct.
Suppose Mr. B's name is there in the share certificate as against A.
Right.
That means A's document is not there, and even B's documents are not there in the society record.
Correct.
But B's name is appearing and he is staying in the flat. Now B wants to sell it to C. So in that case, it is the duty of the society to call for all the documents from B. And if he does not have any document, then a legal process need to be done. That is of giving advertisement in the newspaper, making a police complaint, and if there are certain Xerox copies, authenticate it. If the agreement is registered, get the certified copy from the sub-registrar's office. All this documentation has to be done by talking to some advocates or the legal counsel, and thereafter a necessary procedure need to be done. So the record has to be updated in the society record. Thereafter society may give the NOC, and thereafter he will be able to sell. Till
Great.
such time he will not be able to sell.
So basically, he has to now, they have to start implementing the process of acquiring the documents,
Correct.
getting the needful done, and following the process to get to the outcome of
Absolutely.
getting that thing done. Thank you, Mr. Prabhu. Appreciate
In case of any difficulties, as we are always saying, that they can come with the limited documents, whatever they have, to our association office
Right.
and have a detailed discussion, because every day morning 10 to evening 7, our association, we have about 8 to 10 legal counsel.
Correct.
They can come, meet, discuss, and then initial consultation also can be given free of cost to them,
Right.
so that they are able to understand the process involved, and then we also will be able to give a proper guidance.
Correct. Correct. So thank you, Mr. Prabhu. So be advised that we have MahaSewa Association here at Larapur Center and Andheri West, and you can actually come over to the office. The initial consultation is free, and then of course you will be provided information on what the process is, what is the investment note. I didn't say the word cost, investment, because your unit is worth valued probably in crores today in the city in this city. And so what you got to evaluate is, once you come to the office, you'll be given a proper process guideline, an outline of the process, and then also you'll be told what's the investment involved for you to resolve the issue and create a successful outcome. Thank you, Mr. Prabhu, for providing clarity. Now we move to the next question. The next question is from an individual called Mr. Nanda Kishore Raut, and he's from the area of Borivali in the city of Mumbai. And his question here is: if a flat is transferred by way of sale, I understand that there is 25,000 and 500 as fees to be paid in total by seller and buyer. Now, this specific society says that they must be paying 75,000 each as welfare fund is what the term they are using. Is this correct and legal is what he's asking.
See,
And that second, okay, let's take care of this question, then I will.
See, as I said, there are two different laws governing the transfer of flat in a cooperative society, minimum two laws. One is Transfer of Property Act, the other one is, let us say, the Cooperative Societies Law for the transfer of the shares.
Correct.
Now, as far as transfer of flat is concerned, one has to enter into a sale deed or agreement for sale. He has to pay the applicable stamp duty, he has to pay the registration fee, government fees, and get the document registered. Thereafter, apply to the society for transfer of flat.
Correct.
Once you apply for the transfer of flat, naturally, you are transfer of flat along with the shares. To transfer the shares, as per the bylaw, 500 rupees share transfer fee is obtained, and 100 rupees is the entrance fees for the new person who is coming, and of course 25,000 rupees is taken as a premium. This particular premium is fixed by the government by way of government notification 9th August 2001. Now this particular notification is issued under section 70, under section 79A of the Cooperative Societies Act, where the Maharashtra government gets the power to give any guidelines or the mandatory or compulsory guidelines to the societies. So therefore, this is very much compulsory. Now there are the n number of cooperative court judgments and the high court judgments wherein the societies have collected 5 lakh rupees, 8 lakh rupees, 10 lakh rupees, 1 lakh rupees, whatever he was saying. In that case, if they make a complaint to the registrar, then registrar also can take the action, and by not obeying the government directions, it becomes that committee seems to have committed an offence under section 146 of the Cooperative Societies Act. Thereafter, that entire committee can be dismantled, that means dismissed, because they are not working in the
adhering to the proper process.
Absolutely. So that can be, entire committee can be dislodged, and there can be administrator appointed, and the money you have paid extra can be recovered. So as I said earlier also, the High Court has held the extra money more than 25 lakhs, 25,000, whatever has been paid because of the transfer in the name of either donation, welfare fund, building repair fund, whatever the name is given, all these need to be refunded along with 21% interest. So therefore it will be a huge responsibility on the society, and I would suggest that no society should charge more than 25,000 as a share transfer premium.
Great. So basically, you've outlined the 500 rupees is the
share transfer fees.
Share transfer fees.
And 25,000 is the transfer premium.
Transfer premium. Okay, great. So be advised, and you can communicate this to everybody, that 500 is the share transfer fees, and 25,000 is the share transfer premium. Anything else legally is questionable, and that should be completely, utterly avoided. So thank you, Mr. Prabhu, for enlightening us. Now, the following question is, if managing committee assists, what's the penalty? And you've mentioned that the penalty is 21% on the...
The managing committee can be, dismissed because it is not obeying the law.
Correct.
The managing committee is supposed to function within the given guideline.
Correct.
And if the government guidelines are not followed, then that committee can be dismissed.
Correct.
So one has to make a complaint to the registrar, and registrar can levy that, take
the
the
penalty
action,
and the
including debarring them for the next 5 years from contesting. The people who are responsible for passing this judgment or the resolution, they can be held responsible for not contesting the election. They may be disqualified from contesting the election for the next one full term.
Great. So thank you, Mr. Prabhu, and this is an invitation to each one of you. You can even forward this video to the managing committee, the people who are on the inappropriate track or the erroneous track, because the implications can be far-reaching, as Mr. Prabhu has mentioned. So what we are inviting you to do is send this video out to all the managing committee members who are deviating from the correct processes. Thank you, Mr. Prabhu. Now we move to the question. This person is Mr. Austin Pinto. Now he has asked quite a few questions, so I'll state the questions. The flat, first one was this is an example. Flat was in the name of the father who passed away, and meaning intestate, meaning without a will, right? And the no will was found. So, however, the nominating papers were found, meaning they were discovered in the wife's name, and the society transferred the flat to the wife's name without there being a remark on the share certificate as being transferred as a nominee. Now, the share certificate at the time was of 5 shares. Now, the society then initiated the process of changing from 5 shares to 10 shares, and the wife paid the amount for 5 new shares. The share certificate now is of 10 shares. The society now has issued a new 10 share certificate. The share certificate does not reflect the father's name anywhere. Now it has put the wife's name on the new share certificate, and in brackets stamped it in red as nominee. The first question is, was the society right in only putting the wife's name on the share certificate? That's the first question, without mentioning the father's name at all, meaning the husband's name, right? And on the new share certificate. And if the society is wrong, explain what corrective action can be taken to correct by the society. What corrective action can be taken by the society? If the society correctly put the wife's name as a nominee, also explain, can it be correct as there is a continuity of who actually owned the flat or the unit or the property? Kindly explain.
So as I was saying, we have in the transfer of flat 2 minimum laws governing the transfer. In the present case, it is a transmission, or rather I would say law of inheritance, which is applicable for the property, to inherit the property.
Correct.
On the demise of the husband, will it come to the wife or it will go to the children? So that means either Hindu law, if they are following the Hindu,
Correct.
or if they are a Mohammedan law, or if there is nothing, at least Indian Succession Act, which is applicable to the transfer of the property, law of inheritance.
Right.
Now, as far as shares transfer is concerned, yes, that can be governed by way of a nomination, and in the case of a nomination, yes, the shares can be transferred to the nominee.
Correct.
Now, in the given case, now whenever it is transferred to the nominee becomes only a trustee. So, in the new law, in the Maharashtra Cooperative Society Act, which has been amended, wherein it says, in case the flats are transferred or the shares are transferred to the nominee, it will be considered as a provisional member.
Right.
In the current case which you have explained, in that case, the society has adopted the proper procedure where shares were required to be transferred to the nominee, and accordingly it has been transferred to the nominee.
Correct.
And in the bracket they have written in red that nominee instead of provisional member. That is fine.
That is fine. Okay.
There is no problem. Now, because the new shares are issued, and originally it was held by her husband. Husband's name is not incorporated there.
Correct.
Yes, because shares are given today, therefore maybe by default they have not written. They could have written earlier names, wherever the signature of secretary chairmen are there, they could have written their name and written as HDHD, and new share certificate with the new names as a nominee they could have written. But
Correct.
Now that they have discarded all the 5 shares of earlier and entire 10 shares new has been issued, there they have given the new name. That is fine.
Okay.
It does not affect in any way. The only thing is, as I always say, that just because their name is appearing as a nominee in the share certificate does not mean that they become an absolute owner, they have become a provisional member of the society. The document related to their flat, like agreement in the name of husband,
Right.
thereafter transferring to the wife by way of probate,
Right.
if there is a will, by way of a letter of administration, if there is no will,
Yeah. Okay.
or a succession certificate, that need to be there. If it is not there, just by holding a share certificate in the name of a nominee, they will not be able to sell, mortgage, or the title will not come. Only thing, by way of a nominee, they can contest the election, they can attend the meeting, they can vote and take part in the society functioning, but they will not get the title of the flat.
So that means the title of the flat would need to be transferred also to the wife's name. Correct?
Absolutely correct. Otherwise, her daughter or the children who are the legal heirs also will have a stake in the property.
Okay. So, okay.
Because it is their duty as a nominee, it is their duty to bring all the legal heirs on the record or get the proper documents done from the testamentary department of the Honorable High Court or the district court and then submit to the society.
Great, great. So now here is the next question, same related to the wife has also passed away. Now, again, the wife has passed away intestate, meaning without a will, and made the son as a nominee. Now, the society now has transferred the shares to the son's name, again as a nominee only. Now, the son has also now initiated process of letter of administration with the consent of the siblings. The question now is, how does the court identify whose name the flat is, as the court will now only see the new share certificate which has the wife's name. That also was a nominee basically. So what has to be done to be what answer has to be given if this question arises of who exactly owned the flat or the property?
See, when we are going for a letter of administration in the testamentary department of the Honorable High Court, a petitioner is required to give the entire, what you call briefs,
Okay.
the sequence of the events. Who was the original owner of the flat, how it got into the name of wife, and then how he is a legal heir, and who are the siblings. They also give.
So everybody must be identified.
Absolutely, everybody will be identified. And when the letter of administration is given, so all these legal heirs' names will be incorporated, their consent affidavit will be taken. If they don't give the consent, then of course notice will be sent to them, their say will be heard, and then the Honorable High Court will decide whom to grant the letter of administration. So therefore, we need not worry about whether there was a will or there was no will, who is husband's name, it was there, or father's name was there, and then it was in the name of mother, and mother is a nominee, and
Okay.
he is the father in the nominee. All this is important for the transfer of shares in the society record.
Correct.
But to get a ownership, you will have to go and establish in the Honorable High Court, in the testamentary department, who was the original owner and how it came to wife, and then from wife how it has become to him, and all this will be captured in the letter of administration.
So a complete synopsis or detailed synopsis
That's
will be provided to the testamentary department in the
Correct.
Honorable High Court.
That's correct.
And then they will take care of the process and
Absolutely.
ensure that the
Correct.
proper process is followed.
That's
Great. Thank you, Mr. Prabhu. And again, Mr. Austin Pinto, again, that assuming that the court issues the letter of administration and the same is also recognized by the society, right? And the transfer of the flat is made in the son's name after filing of the relevant papers. Is there any other balance procedure other than the society, like having to go and register the change name in, say, the ward office? So you've already addressed
I'll just explain you. Once you get a letter of administration, he becomes the administrator of the property.
Correct.
Because he is an administrator of the property. Thereafter, if he wants to sell to someone or he wants to get it transferred in his own name, then he has to go to once again to the Bombay High Court and get the permission either for sale or to transfer in his own name or anybody else's name, and with the permission of the court, then that transfer deed has to be executed, and that transfer deed has to be registered with the sub-registrar office on a nominal stamp duty, because that court fee of 75,000 is already paid for obtaining a letter of administration. Therefore, there will be a nominal fees of, let us say, 200 rupees. Based on that, transfer deed also can be executed and this need to be registered. Thereafter, you become the owner of the property.
Perfect. So expect that Mr. Prabhu has enlightened Mr. Austin Pinto specifically on what has to be done.
And one more thing will let us understand that this is a universal problem in every society, and therefore I suggest whenever this type of cases appear, whether it is because of the death of the member, due to nomination or anything, they should always consult an advocate, or they can come and have a free consultation in our association office, so that it becomes more important. To take an appointment for free consultation, they can contact 022 4255 1414 or 022 4255 1425 or 022 4255 1432.
Great,
So,
Mr. Prabhu.
yeah, thank you very much.
Thank you.
Yeah, go ahead.
So here we at MahaSewa are here to actually serve you and ensure that we can avoid you getting a lot of future pain by you coming physically or calling us at the office and then taking a prior appointment, a recent prior appointment, so that we our staff can completely focus on your situation, put the spotlight on you, and ensure that we can create successful outcomes for yourself.
Yeah.
Now we move to the next question. Now Mr. Austin Pinto, now this is another friend of his, this is another situation. Now can somebody who is also a legal heir, and the only child of the parents, in the event of their demise, give the flat on leave and license agreement? The son is the nominee, meaning he's the nominee, and can they give it on leave and license? And when the legal, I'll just amalgamate all the questions. So would you like to take one question at a time?
No problem.
Okay, so let's take one question at a time. And
Yeah,
then
see, a nominee normally should not be allowed to sell the flat, or nominee is not allowed to give you on a long lease basis. But of course, on leave and license basis, because the nominee has already got the flat share certificate transferred in their name, they can give on leave and license basis. There is no problem.
so in an 11th month legal license, they are
okay.
okay. Okay. Now when the legal heir is appointed as a nominee, and the other legal heirs give a sworn affidavit relinquishing their rights to the property of the flat, right? And an NOC stating that they have no objection to the flat being transferred as an owner in the name of the nominee, can the society still insist for a letter of administration?
Yeah, absolutely. Because as far as the amendment which has happened in the cooperative law, and as well as in the Indian Succession Act, or even in the Hindu Succession Act, or in the law of inheritance, whatever we are talking about, unless until the document is properly vetted and document is given by the testamentary department, you do not get the title to the document. Or in case you have situation where you get a NOC or the affidavit, that is not sufficient. You have to have a release deed which is duly registered in the sub-register office, and then you have to get a heirship certificate saying that so and so expired and there are only 4 legal heirs. So that has to be certified by either district court or by the Honorable High Court. Thereafter you can enter into a release deed. Absolutely, there is no problem. But if you say that only by giving an affidavit on the notarized document on a stamp paper, that is not sufficient document. So society is entitled to ask for letter of administration.
Great. So Mr. Austin Pinto, thank you, Mr. Prabhu, for enlightening us. And Mr. Austin Pinto, kindly note that the letter of administration, they have to follow the processes, and the society can actually, in its right, legally demand and request for a letter of administration. Now we move to the next question, and the next question is that's Mr. Umesh Gurao. That's the name of the person, Mr. Umesh Gurao, from the area of Panvel, right? Panvel. Now, if the flat is on wife's name, can her husband's name be added later with doing again, meaning again registering, or is there any way to add the name or husband's name later on?
Correct. In order to add the name of husband in the share certificate, naturally they have to be made a joint owner. In order to become a joint owner, they have to enter into a gift deed. And now husband and wife gift deed can be entered into on 200 rupees stamp paper,
right?
Because there is a blood relation and without any consideration, and registration fee also is 200 rupees. One can execute that and go ahead with it. so that the husband's name can be added in the share certificate or wife's name can be added in the share certificate. There's no problem.
Fantastic. So it's very simple, 200 rupees. So basic cost or investment is only 400
That's
basically. And it's a straightforward process.
That's correct.
Thank you, Mr. Prabhu. Thank you for enlightening us. And Mr. Hemant, Mr. Gurav, I expect that Mr. Gurav, we've successfully answered all your questions. Now, Mr. Prabhu, what I want to know is is there anything else you'd like to add in terms of value or?
Yeah, I would say that the flats is costing crores of rupees. It's a real estate property. It is always taken for the next generation. So whenever you are buying a flat, you need to verify the title documents of the flat as well as the membership in the society, and then take the help of legal counsel so that it becomes much easier. And the last, I would say that yes, our association is always available for your guidance. And next week on Wednesday at 12 o'clock, we'll come back along with the same Prabhu ke saath khas baat, a topic on nomination and law of inheritance. So this is very important topic which I understand that a lot of societies are would like to get knowledge on that. So we'll come with the nomination and law of inheritance, how it is different and what should be considered and what is the provision of the law. You can always ask questions related to that. Thank you very much. Over to Kevin Hirwani. Thank you.
Thank you, Mr. Prabhu. Thank you for enlightening us. It is of tremendous value. You provide, of course, you all as the participants. We have been consistently requesting you. We are looking to expand the participation. Your participation, your cooperation is extremely imperative for us to expand our horizons, because everybody deserves what you deserve the best. Now, I want to add that nomination and
the nomination law of inheritance.
Okay, so next Wednesday, stay tuned at 12 p.m. We are going to cover, Mr. Prabhu is going to cover the topic of nomination and the law of inheritance. It is an extremely important topic so that we can follow proper processes for a bright present and a superior future right now. And we take your leave. We thank you for your participation. Remember to invite everybody for next Wednesday. I believe that's the 10th of February 2021, 12 o'clock. Invite all your friends on the show, live on YouTube and Facebook. And yes, in the meantime, make it a pleasant and a great week, a phenomenal, spectacular week right now, because you all deserve the best. Thank you.
Thank you very much.
So are you